Welcome to the Priggya Arora Show, where we discuss law, innovation, and entrepreneurship with people who have been there and done that. My name is Priggya Arora, founder of PA Legal, an intellectual property law firm in India. And our guest for today is Stephen L. Anderson. He is a trademark and branding lawyer and founder of Anderson Law. Welcome, Stephen, on the show.
Thank you.
So, Stephen, we'll start with your life story and how did you become a branding lawyer?
Well, actually, when I was in my penultimate year of high school, it was the time that I finally decided to go to college at all. But I knew immediately that I was attracted to law, government, and politics in particular. I was fortunate enough to win a contest of young men who they had a program up in Sacramento, California, where they sent the top high school student of each high school. And for some reason, they selected me. I was most improved. Up there at Boys State is what it was called, but presented by the American Legion, I realized that I really had an affinity for an interest in law and government, if you will, the branches of government and how things work. And at that time, I really was determined to get a firsthand look at that. So I ended up going to the University of Southern California, where they had a politics in Washington program. And there I spent about 7 or 8 months living in Washington, D.C., where I was able to serve as a Senate intern for the Majority Leader's office. At the time, Ronald Reagan was the president and the Republicans were in power. When they asked me, a young man, I was, 17, 18 years old, whether I was Republican or Democrat, I just chose the opportunity to get, if you will, the closest to the flame that I might be able to. And if you will, at that time, it was very hip to be square, if you will, so I traded in my t-shirt and skateboard for a suit and tie, and I went to Washington, D.C., and there I was both, enchanted and disenchanted by the experience, because having an opportunity to get so close to the flame, if you will, I may have got a little bit singed. And that's by, if you will, the role that money plays in American politics in getting decisions made did not suit my view. So at that time, I was really looking for something else to do. I knew I was going to law school. I knew I was going to go to Washington, D.C., and I knew that it was going to be Georgetown. So at Georgetown Law, that took me on a different twist where I became interested in criminal law. And I ended up working at the Washington, D.C. Public Defender's Office. I worked in a different prisoners' rights program, and I actually taught a class to prisoners inside Lorton Penitentiary about street law and the rights and responsibilities that people have related to the law. Following that, I returned to Los Angeles, where I became a deputy district attorney. I spent nearly 3 years prosecuting criminal offenses, from misdemeanors to felonies. I was there at the time where the Rodney King riots broke out. I was there up until the time of the O.J. Simpson trial. I was placed in East LA, Inglewood, South Central, and I really did a tour of duty. But what I'm most proud of was that, if you will, I didn't have fear, but I knew I had responsibility. Yeah. So in some cases where you get to become the public prosecutor, there are tough decisions to be made, and often was able to make hopefully the right ones. But eventually, if you will, the life of a criminal lawyer became too much, in that my days were surrounded with crime, criminals, victims, their pain, and even the bad guys who went to jail were not quite happy. So again, the relationship that a lawyer has to do a job can often, how you say, determine who they become inside.
Correct.
And to me, it was just too difficult, in that, well, again, it's real life. And again, there are certain things that just didn't say. But you know what was the most interesting thing was, I felt that I was extremely well qualified to do litigation. And while I was blessed to have tried more than 35 jury trials, thousands of preliminary hearings and whatnot, I really felt that my sword was blunting because I was no longer writing. As a prosecutor, you spend your day questioning witnesses. You rarely write briefs. And after about 3 years, I felt that, how you say, my skills could be honed better than continuing in the spot I was. So at that time, I was very fortunate to meet a man who needed some assistance in a number of IP cases. I was able to take over from an attorney who was retiring, and I immediately started with 3 of the most exciting cases you could imagine. One was on behalf of Hard Rock Cafe, and they were trying to stop all the vendors on the Venice boardwalk from selling illegal and infringing shirts. Another case was on behalf of 20th Century Fox, The Simpsons, which was very similar. And finally, the third was with Tag Heuer watches. And in each of those cases, I was, how you say, presented with the task of obtaining an injunction, an order for seizure, where at that time we could go down with uniformed or non-uniformed, rather non-uniformed police personnel who had the right to serve a injunction, and they often had weapons. And they would come down, and we would literally serve the individuals, who were often John Does, based on the presentation of the evidence that was conducted by our investigators, namely taking photographs and counting and identifying the products that they had seen. So it was a fabulous opportunity for me to begin my own solo practice with, if you will, a mentor who was able to show me what I needed to do. And I fortunately met a few lawyers who also were, how you say, of need of IP attorneys, and my interest became, fortunately, exclusively devoted to this practice. Oftentimes people would ask me to handle a criminal case or a family law case, and I had the responsibility and both the privilege of saying, no, I've got to stay within my, and this was early on, to stay within my wheelhouse. Again, this was in the early 1990s. I was able to do all of the copyright renewals for a famous actor and artist named Red Skelton, who at that time, the Copyright Act permitted renewals that were mandatory. In other words, if you didn't file, you could lose the rights. Today, through the Sonny Bono extension, they're all guaranteed as the life of the author plus 70 years. But back then you had to renew your copyright registrations. So that was another thing. Anyway, as a result, I was able to build a firm and a practice that was exclusively an IP. And through the years, again, I've worked for a number of well-known IP firms after that, and until my partner at the time, what happened was I was representing Anheuser-Busch, Budweiser, in a multinational litigation that sent me to Korea and Hong Kong and Taiwan to supervise and coordinate each of the individual cases, so they didn't end up saying things or arguing in different jurisdictions what they were saying elsewhere. Queen's Counsel had coordinated on the end of the company called Budweiser Budvar of Budoviki, Czechoslovakian, or at the time, it's the Czech Republic now. Anyway, so this was an interesting opportunity. I found myself in Hong Kong in the early 1990s, and I went to an internet cafe, and I brought up, homesick, I brought up a few websites I could see, and it dawned on me that the same products could be viewed online by everyone, and suddenly through the internet, if you will, both branding and product knowledge, or acquired distinctiveness, as we call it, could be obtained through a machine rather than the old school marketing methods. Working for Budweiser, I had an opportunity to learn about product placement and advertising, and how they did their multinational through their own in-house advertising company. And I became very interested in the creative aspects as well. Not just the legal aspects, but often the connect or disconnect between marketing department and the legal department, which often, can lead to some IP issues. So anyway, ultimately, I went to my boss at the time, and I said, we should create a law firm that addresses internet disputes like domain names and things like that. And he said to me, we've done it this way for the last 100 years. We'll continue to do it the next 100 years. He was a man from India who was a fabulous boss, and gave me some opportunities that otherwise I wouldn't be able to have. And I disputed his belief that the internet had not fundamentally made a change in both the way we understand law, especially in the field of IP, and how we relate to others around the world with the issues that are going to happen with or without intent. I note, for example, I have the palm of my hand. There's the Palm Pilot, the palm tree, and in every language, there's a word for palm or sun. And whether it be Sun Microsystems or Sol Cerveza beer, the question is, who has the right to use such simplified words and images? And also the interaction between the .coms and the national TLDs. Well, all these things were ruminating in my mind in the early 90s. And I really set to task to attend to those issues. So again, while I may have at times wanted to give up, today it's no different. Today is a whole new frontier. It's all about NFTs and virtual worlds, coins, and currency. And I've continued, again, through programs such as INTA, the International Trademark Association, and other particularly firms and experiences with colleagues around the world, tried to really stay up on what is IP, how do we address the issues internationally, and what is fundamentally fair in terms of these issues. I see oftentimes people will ask me if they use a certain mark or own or possess a certain mark, if they might prevail in a case involving another mark or issue, of course. And to some extent, while the question is typically one that we as lawyers would like to say it's a legal issue, it isn't always, because in terms of fact, it's the consumer's belief and understanding of who and where the product is made, as I call it, the source and origin of those goods. And oftentimes through, again, I'm speaking to India from California, we may have a different association with certain words, brands, sounds, and symbols. My favorite example is Delta. Delta, the triangle, is the fourth letter of the Greek alphabet. It predated the English language, and it's been found on pottery in ancient Greece. As such, when someone might say, I'm Delta Airlines or Delta Faucets or Delta Dental, that they only have a piece of that recognition and understanding of what that brand might mean to consumers. I mean, I can go on the Tri-Delta sorority, but again, I don't believe there is, if you will, always a fine line or a rule that one might apply in many of these cases. And that's what makes IP so darn interesting, is that, you know, it's really like a chess game that you play on multiple levels, if you will. So that's why it's always fascinated me, and that's why I've always engaged in this type of practice. Now, throughout the last 30 years of practice, I've had cases in maybe 13 different federal jurisdictions, that is states outside of California, where I've tried cases or handled IP matters. And anyway, I was talking to some people yesterday about it, and I think the most interesting thing we also get to do, that our other attorneys that don't practice IP get to do, is really travel and FaceTime and work and understand through conferences and our colleagues worldwide. And the second point I want to make is that IP attorneys, even the best litigators, have to be sharp at solving problems that clients have and seeing an end result sometimes that might never have occurred to a typical litigator. In other words, a license, a assignment, a joint venture, you know. And we think about how brands can be associated, like ketchup and McDonald's. Again, for many years, they only served Heinz, and now they have their own McDonald's brand of ketchup. So again, where brands are associated through movie tie-ins, through product placement, and even through joint branding, you know, where you might see 2 or 3 products sold together or presented together as a consumer solution or opportunity. So those, I think, are the most interesting: the licenses, the joint ventures, you know, the transactional work, and the advertising. Absolutely.
So, Stephen, you have been in this industry since 30 years. You have seen different phases of IP. At the time you might have started, the IP laws were just developing. They were just coming in and, you know, starting. The laws were different. Now the laws are different. So what, in like you just told, in the current scenario, we have NFTs, we have crypto, we have so many latest technologies, and people are building their brands in metaverse and things like that, where infringement can happen to a greater extent. So what do you think that, you know, small aspects, like what people can keep in their mind while starting their own business or while keeping their business name?
Well, again, I think the most important thing to keep in mind is doing an adequate search. And I think it was the Harvard report a few years back that said, basically all the words are taken. Everything in the English language is taken. And again, that's not exactly, I'm paraphrasing, but they said if you went through the dictionary and compared it to brands, and again, I gave you examples where I had a project that I assigned to my law clerks years ago. I called it the Delta Project. And they came up with over 70 different registrations for the word Delta. And again, how do you make a good source origin connection when there's even more than one in a class? But constantly, if you will, these are issues that the market should decide. The consumer should decide. Again, big brands sometimes will bully smaller brands not to use a certain designation. And in other cases, that designation may or may not be something that the consumer can see functioning as a trademark. That's a new issue the trademark office has
Correct.
been handling here in the States. But also to comment quickly on your earlier observation, yes, the law has changed. Since I started, they have the DMCA, Digital Millennium Copyright Act, which provides protections for music and software and digital recording and streaming, and video, and just about a number of other what I was meant to suggest in my mind is that as laws change to address the new technologies or distribution models, NFTs you mentioned, one of these days, someone's going to have to address this issue that is a real hot potato, and namely, what is the true value of a virtual token, a virtual ownership of immaterial products or items. So again, while we today see the market turning towards the metaverse, and I myself recently has done some interesting work involving both characters that appear in the metaverse and how AI itself may have rights or rights created in terms of what AI can do. So the point is, law is going to have to, the laws, legislatures around the world are going to have to address a number of these issues. And that's one I don't want to, and when it comes to, again, regulation of the metaverse, it's,
Correct.
I'd like to think that's for another generation.
Wow. So Stephen, like you just touched upon an issue, like bigger brands are there now to stop the smaller brands, because we have also started facing this issue. Like initially what used to happen was there were a lot of counterfeits of the bigger brands in the market, and they used to come and we used to protect them. But now it is a kind of reverse situation. For example, smaller brands are operating since 10-15 years, but they are not part of a big brand. Then big brands would come up and try to trademark something similar to the smaller brand so that they can use their goodwill and acquire more and more companies. Can you suggest some steps which smaller players can take in this scenario?
Well, we see both sides of that particular seesaw, if you will.
Yes.
Recently, it's been reported that a man who had the domain name and or trade name Meta has, if you will, been ransoming that to Mark Zuckerberg vis-a-vis whether it be litigation or vice versa. Again, more particularly, like you said, I've seen in my career, big brands muscling their way to stop smaller brands. Again, it's a difficult question, but it really comes down to how one might go about protecting their IP. With every good or service, it's about letting the public know who you are and what makes you different. So I always counsel my clients that they should have their mission statement right up front. Also their imagery, their colors, their logos and descriptions. They need to be consistent and clean. Again, some of the best ones that again, I call it the trilogy or the trifecta. Here we go. McDonald's, the Golden Arches, and their slogan, which may change from time to time, but it's always some popular slogan that kind of hits there with just a few words. We have BMW, the ultimate driving machine, and the designation that's on the hood. And of course, the ubiquitous Nike, just do it, and the swoosh. So that I like to use in my own advertising. If you may have noticed, I consistently use my branding, my logo. It may change color from time to time, but again, I think that's very important that companies, if you will, figure out exactly even to what font you're going to use.
Yeah.
In some cases, the Coca-Cola font and color is, if you will, so well recognized that it's important that we realize what does it mean to us when we break these things down.
Correct.
For example, while everyone will tell me that Coca-Cola is the most famous and valuable brand, at the same time, I say, well, there's Pepsi Cola and other colas. So obviously Coca-Cola must only have protection of the Coca part. But then when you look at the Coca part, it may be derived of the flavor comes from cocoa beans. And again, that so when it comes to discussions of brands, their fame, their protectability, their registrability, and the oppositions that ultimately come, or petitions for cancellation that come by those who might claim senior priority or common law rights, I believe that it still comes down to every case in terms of what the proof shows. And for that reason, I counsel the larger client, the one who is the bully, if you will. Today's C&D letters, today's cease and desist letters are written a little bit different than they were 10 years ago.
Yeah.
In part because courts have recognized declaratory relief actions by people saying, hey, they're telling me I can't use this, and
Yes.
letting the case flow based on the defense bringing it in response to a cease and desist. But some of the more famous examples of beautiful cease and desist letters include the one written by Harley Davidson's counsel, which usually says something like, we're so glad that you're a fan of our product.
Wow.
You know? And we know, if you will, that you're doing your best to get the word out. By printing it on shirts, but we have a responsibility to protect ourselves and can't really allow you to, to take these steps. So, and again, that's a much better approach, if you will, than, hey, I'm going to get you and burn down your village if you create something on Pinterest or Instagram. So the ubiquity of increased trade runs with it. The increased likelihood that brands need to take extra steps to protect themselves, and the oftentimes public response. I like to think, if this is published on the internet and everyone reads it, how are they going to react?
Yes. I think, Stephen, this was an eye-opener for me because, we also receive cease and desist notices. And what we do is, like, in order to protect ourselves, we'll just go and file a suit, like you said, the declaratory suit. And then the other party is on a weaker side because we are the ones who are initiating the suit in the first place. But if the language of cease and desist is such that it's not threatening, then people would not be able to take this defense.
That's part of my reasoning, but also, again, if you will, it's also the court of public opinion.
Yeah.
One should never bite off more they can chew. One should never make statements they can't back it up. And, if you're going to point to center field like Babe Ruth, you better be able to hit it there.
Yeah.
And anyway.
Yeah, I was saying, but still, if legally it is correct, and sometimes what happen is this defense is given to us, but people are using it in the wrong manner. So we'll have to weigh the situation and probably use what kind of strategy we'll want to use.
Similarly, I think there's another problem, and that can be, I once represented a company, a very well-known skateboard company, and it was very popular because they did a lot of advertising in skateboard magazines, and we're always out advertising at events. And as a result, like, here's another example, Harry Potter, where you get a very strong public who loves you. They really are emphatic about the product and they want to share it with their friends and whatnot. And again, that unfortunately leads to them registering domain names like brand guy, brand kid, again, in this particular, it was skateboard name girl, skateboard name boy. And I could spend the entire day sifting through websites. Similarly, if they're popular band, popular song, recording artist, and again, now even virtual character, it turns out that you really need to be able to protect that from, now again, when I mentioned Harry Potter, as I'm saying, for every coin, there's another side to it, in that you don't want to alienate your audience. In this case, I believe Warner Brothers, the owner of the Harry Potter franchise, had written a letter to Harvard's polo club not to play Quidditch anymore because they were using the name, that they were playing Quidditch, and they were asserting that, you can't do that. So I'm not familiar with the facts of that case, but it's just another example where, again, you don't want, especially if you're in the situation of like a Marvel or a DC Comics, you don't want to alienate the very fan or supporter of your product. And the case of Harry Potter, there were people making, if you will, derivative works, their own worlds, drawings, comic books. And again, based on the characters that are well known and well loved. And ultimately, you as a brand owner have to make a decision on how to address that.
Yes.
And that's just, if you will, one of the costs of doing business that oftentimes the most popular brands are able to easily afford and address. And the least popular and smaller companies are not always able to address.
Correct. But I think this is a very valid point, because sometimes, like you said, supporters and fans help us build a brand name in total. So it's up to the trademark owner that to decide whether they want to stop them, or whether, to what extent it is okay to let them practice.
I think Taylor Swift early on in her career encouraged her fans to wear T-shirts and make things and create pages that used her IP in order to build her brand, which today I don't think she's quite as fond of but again, that in any case, that too is, if you will, both a cost and blessing of the fame that it brings and the choices that, ultimately occur.
Because, Stephen, I also think if we allow it to a greater extent, can it lead to brand dilution and cause a problem against us?
Absolutely. And even, cases of selective enforcement.
Yeah.
Where again, you can't, I've seen that in hundreds of cases where defendants might claim, well, he or she is doing it too. But that isn't always a great defense to IP cases in particular.
Yeah.
But it only relates, if you will, to showing the weakness of the trademark's fame, or the, if you will, first sale doctrine that, I've got an interesting case right now that I'm working on where my client purchased a baseball card and then resold it on eBay. And it turned out that that was allegedly counterfeit. But again, what are the responsibilities of someone who owns a CD-ROM, a disc, and how these issues become? And frankly, I'd like to think that the DMCA and the law is more predictable.
Yeah.
But as you have led me in our discussion today, has talked a lot about, if you will, the economic issues that surround IP decisions and how companies and brands address, their enforcement decisions. So it's a tough question, especially when one notes the cost of lawyers.
Yeah.
I read something last night that really made me smile. It said that Abraham Lincoln was once asked to represent a man who was owed $2.50 by another debtor. And he told his client that it was just too difficult for him to get involved. And if he really wanted to, he would have to pay $10 to Abraham Lincoln to represent him to collect $2.50. The man agreed. Lincoln walked across town, gave the debtor $2.50, and then settled the case when he gave it back to his client. Now, I don't know if that's true, but I did
But
read
that
that.
might be people
Don't
do.
believe everything you see on the internet, but if you will, I'd like to think that, again, there's some role in the civil lawyer's life to
Yeah.
decide whether it's worth it to pursue cases that may not either have a pot of gold at the end, that might be for spite, or might be for, again, for some other reason than getting what is due.
Correct.
I'd like to conclude that thought with talking about a table topic I was involved with a few years ago, where an in-house counsel laid out 5 ways to handle litigation, and none of them included settlement. And I said, ma'am, you've got to consider your responsibility to your stakeholders and the possibility that maybe a creative approach might alleviate the need for lengthy and expensive litigation. So again, I think the best lawyers are ones who are always looking for an opportunity to resolve and solve the problem,
Yes.
rather than just fight for Pyrrhic victories. Because at the end of the day, again, we all need to have a work-life balance, and we need to go home respecting what we do for a living. And unfortunately, that's one of the reasons why I work for myself rather than for a larger firm, because I get to make the decisions that I can live with, rather than those that the firm might dictate or the client might dictate.
Stephen, quickly, I'll just touch upon one more issue. Like, there are brands who do not register their names. In India, we do have practices like, passing off, and we can institute a suit again, in the passing off. So what is your take on unregistered trademarks and how we take care of them?
Well, that's a $64,000 question, in as much as unregistered brands have recently, in my view, been able to win a number of petitions for cancellations and oppositions at the U.S. Trademark Office, where they are able to demonstrate true priority of use.
Yeah.
But again, I think that we once again need to think about, is it priority of use or is it consumer confusion? So again, in the end of the day, if there are 2 brands that operate in the same legal sphere, but yet are so far apart in the terms of what their goods and services are, or so far apart in what their geographical sales are. In your country and mine, we have numerous what we call time zone differences. We have miles from, if you will, Lahore to Mumbai, and New York to California. So the truth is, not every brand can, if you will, promote its products on the level in which they want to have legal protection.
Correct.
So it's strange, but again, I don't have, if you will, a philosophical bend one way or the other as to who's right. But the question really comes down once again to, what does the consumer think? What does the consumer believe? And how are they being confused by the relationship between these brands and these goods or services? So again, my best example I like to talk about is Delta Airlines, Delta faucets again. But at the end of the day, what about Delta cab service? Could it be a car that picks you up at the airport, part of the airline? Would you believe that it's a continuation of the transportation services?
Correct.
And I think the default answer that the courts and the administrative offices, the IP agencies, has been on the safe side to provide those who have prior registration or demonstrable use to have the senior right to registration. So, but at the end of the day, that doesn't always answer the question of whether the registration itself is effective to prove infringement.
Yes.
Because that's a whole different question. So again, sometimes people misconstrue a trademark as a freedom to operate or a opportunity to exclude others. And again, you're looking at the shield sword approach, and the answer really comes down to, how does the public believe it? In other words, you can have 100 registrations, and if the consumer was not confused, he knew where it came from, and he knew what he was buying and knew what he was getting, then again, everything else is simply a technical exercise. So to be able to demonstrate damages means that you need to be able to show that there was a, I'd like to say confusion, but the truth is the standard is a likelihood of confusion.
Yes, absolutely.
So will the consumer be deceived is not always the test. It's might the consumer be deceived. Again, tie goes to the runner. The registrant gets that prima facie validity and benefit of having the registration as grounds for its lawsuit. So, it's, again, these are the greatest thing about IP is that we can split a hair 100 ways, and we can argue these cases until, the Supreme Court tells us to stop.
And
But,
they will never tell us to stop.
yeah, that's only I suggest.
Yeah. So, Stephen, we'll quickly come to rapid fire round. And I'll ask you 3 questions. Please answer them very quickly. These questions are about you and your life. 3 things that you are grateful for.
3 things I'm grateful for. Definitely my family. And I'm grateful for having had an opportunity to live the life that I've been able to make. So again, I'm certainly thankful and appreciative of, the gifts that, I've been bestowed with, the opportunities I've been bestowed with, the things my parents and my community, have bestowed on me. But I also like to believe that the harder you work, the luckier you get.
Yes.
What else am I grateful for? I'm grateful for a community of international IP friends who connect on a regular basis. I'll hold up my phone, but right now we're missing AIPPI in San Francisco.
Yes.
Everyone wants to know, are we going to attend in Korea and meet for next year's INTA in Singapore?
Yes.
So again, I love my IP community in that we really do look forward to getting together and discussing these things that, if you will, average people don't care about and we're fascinated with. So I'm definitely thankful for them, my friends around the world, in Germany and India, in England, in Costa Rica, and again, and Korea and China. And again, we have a network of friendships, again, that goes deep, much deeper than the work we do.
Yes.
Final example, I'm going to a wedding in Mexico this year, the second wedding in Mexico of an IP colleague that I've been
Wow.
able to attend. And again, it's all part of being in a community that you respect and you would, learn from and you connect with.
Absolutely.
Yeah. Did I get three?
Yes. Your community, your family, and the way you have been able to build your life.
Yeah, work-life balance, I think is if you had to define that, yeah,
Yes.
is
Yes.
to be able to make and do the things you want. And when again, my wife is here. I'm broadcasting from home. I got to give her a shout out. Absolutely.
Now, Stephen, two traits that you think are useful for a professional career.
Oh, well, the first one, of course, is an overwhelming obsession and drive to do what it is. You have to love what you do.
Yes.
Having practiced in criminal law and done some family law and done some other types of law, I really do appreciate, what I do in terms of IP, because as I hope I demonstrated, it continues to amaze me in terms of the choices, the decisions, the opportunities, and the ever-growing changes of technology that really relate to the world around us. And how would you say the need to demonstrate these things? Over the last couple of years, we've seen a monkey take a picture of himself. He
Yes.
wasn't allowed to have the copyright. And now the issue of AI creating artwork and music and how that relates. But it's and we talk again, NFTs, the metaverse, it's constantly and daily a new experience, from domain names, trademarks, copyrights, trade secrets, designs, logos we mentioned, but again, that's all part of a world that we call intellectual property. And for me personally, the interrelationship between designs and patents, between product, what's the word? What was it that Jackie took? Product. My oldest daughter, she graduated from Otis Art and Design, and she gave a program on basically interspatial branding.
Yeah.
Today, unlike the old days, it's not just a billboard on the side of a road.
Correct.
Here, you can go into an Apple store and know you're in an Apple store. There is, there are casinos in Las Vegas or around, how you say, hotels around the world that have signature scents from the moment you come in, through the candles and the hair wash products that become, if you will, associated with your experience. So can those smells and sounds be trademarked? And the answer is absolutely yes.
Yes.
So once again, the ability to create an experience where one sees the way a product is presented and or is given a new service, like the Genius Bar might be to the Apple Store, that it's an experience that wasn't there before, and how they might associate that brand with that experience. So experiential marketing, that's what she called it. Yeah, my bad. I just remember she had a course in that particular subject and had done some, fortunately for her, she's been able to, if you will, design museum installations that, if you will, are kind of integrated in that you're stepping into a different place where you may be encountering the artwork or author view. So whether the room is light or dark, painted or not, whether there are flashing lights or still lights, and even the way a product might be presented. I recently saw the movie Top Gun Maverick, as everyone else did, and they had 3 screens. So they used screens on the side, not just the front, but they had projected on the side walls. And at some points, it gave you an interactive experience of the planes flying by. I'd never seen that before. And before we left the theater, we saw one of the one of the movie theaters had seats that moved as well when the
Wow.
planes flew
Yeah.
there. So they called that 4DX or something. But again,
Yes.
all I'm trying to illustrate is that the presentation and the experience of the service, the marketing, the end result of what the consumer believes and understands is, if you will, should be protected. I believe that, anyone who comes up with, as if we call it intellectual property, an idea that can tangibly benefit people,
Correct.
it should be, they should benefit from that, but
Mm.
only to some extent, because as I also like to remind everyone, you can never copyright a ham sandwich. At the end of the day, it's just going to consist of bread, ham, cheese, lettuce, but again, there are some things that are either too obvious or too pre-existing, and even in some cases, just, if you will, too difficult to
Yes.
establish the brand source association. So anyway,
Mhm.
uh, that's it. As you can tell,
Mhm.
I love what I do, and
Yes.
I really do.
So, Stephen, what is your one aspiration that you have for the future?
Oh, if anything, obviously after now almost 31 years of practice, I'd like to think that I'd like to step away from the day-to-day litigation experience and do, whether it be consulting. I'd like to be a professor
Yeah.
and teach folks, how to do it right. I have a fascination with the federal rules and the trademark rules. I am such a fetishist when it comes to the pedantic word of the law that, again, I feel that I could be a good instructor on how one relates and addresses these things when they're filing motions or presenting evidence to juries. So
Yeah.
again, as I come to the, if you will, the penultimate years of my career, I got to start thinking about that. And also, finally, I envision that I will write some stories, fictional stories. And since we're broadcasting in India, I will say this: I have a secret desire to be the bad guy in all the Bollywood movies. For real. Oh,
Wow.
I would love to be that horrible white guy in the Bollywood. I could be
Come
so
to
good. Oh,
India,
you
Stephen.
terrible.
Stephen,
I
you
could be.
should definitely be here.
That's what I want to do. That's my retirement plan.
Wow,
To
awesome.
to be the villain in the Bollywood movie.
I love this answer, and I want you to see as a villain in a Bollywood movie.
I'd be
I
good
wish
at
it comes true.
it. Well, I'm looking for an agent. So if you're down in Mumbai,
Yeah,
you have an opportunity.
yes,
I'll
whenever
send
I
you my
come to know about this opportunity, I'll definitely contact you.
email. Thank you, Priya.
So, Stephen, any final thoughts before we conclude this podcast?
Again, I think to everybody out there, I would like to say that I hope that I've presented the counter to what one might expect. That's been kind of my intention today, is to demonstrate that as an IP attorney, we're not like the rest of what people consider a lawyer and how they work. I mean, while we are fundamentally able to handle the motions and the documents and the litigation and the paperwork and the registrations and the renewals and the oppositions and the cancellations and all the fancy things that we do through our jargon, that at the same time, if you will, that we understand that as a worldwide people, we are all connected, and brands, if you will, all need to coexist and look for opportunities where they can both find a common benefit. And the example I want to give you was many years ago at an INTA, International Trademark Association opening keynote. The president of Warner Brothers was complaining on behalf of DC Comics all about how the MCU owned by Disney was costing them market share. That basically everybody now wants to go watch the Avengers instead of Batman, Superman, and Wonder Woman, and they were and continue to plot their own, if you will, DC world versus the MCU.
Correct.
But then when one thinks about Comic-Con,
Yeah.
together they are creating a bigger universe of fans of superheroes.
Correct.
And again, rather than fight and try to wipe each other out, if they grow the size of the pie, the market share doesn't become as important.
Yeah.
In other words, I'd rather have 10% of $1 million than 100% of $100. So again, if brands can understand and find ways that they can collaborate with other brands to create a better end result, and it does not confuse the consumer. And do you know what? I'm going to send you one day, very quickly. The example of that only exists in one place, and that is the registration of the trademark superhero in the
Correct.
United States. It is actually co-owned by DC and I guess Disney or Marvel's parent company.
Yes.
But again, it blows my mind how both that's probably the only example where I've ever seen co-ownership of a brand. And last time I looked, the specimen on behalf of the filing was complete nonsense in my view.
Correct.
In other words, it was inadequate and insufficient. And I don't believe that, truthfully, that the public can identify the term superhero with any one trader, whether they be DC, Marvel, or anyone else.
Definitely.
Namely, you don't have to be a character created by those companies in order to be a superhero.
Correct.
Each of us are superheroes every day.
The thing is, Stephen, just my thought. I know we were concluding this podcast, but I cannot stop sharing. Like, sometimes the problem is that these marks are so old that at that point, trademark laws were very different, and generic words used to get trademark because they did not have any competitor to fight. But nowadays we can't protect like word superhero, and clients would come to us and say, because they have the word superhero protected, we can have a similar word protected. But at that time the laws were very different. They did not require the usage affidavit and things like that to the extent what they require now. So I think that
The
is
bar has gotten higher.
correct.
And here in the States, again, within the last, since November of 2017, they instituted a new policy by which the board can reject a mark, an examiner can reject our mark because it doesn't function as a mark.
Correct.
Now, again, that isn't even in the Trademark Act.
Yeah.
But I believe, and there's been, these cases are like once a Marine, always a Marine, or my favorite example was the one Drive Safely, owned by a insurance company. Again, is the public really going to recognize that? But it's a different analysis and it's a higher bar. And if you will, it's more difficult today to get a trademark than it was 10 years ago. And I know it's probably, if you will, been incrementally headed in that direction, probably long before I was ever born, and will continue long after I'm long gone, because of the increased number of players in the marketplace.
Yes.
And more importantly, as I observed earlier, because of the international nature of common commerce today that was not in place back then. I mean, let's face it, in the 1950s, for me to come visit you would take weeks.
Yes.
Now I can be there virtually in hours, and we can converse and use the internet and televisions and radio and all these wonderful technology to connect and share our lives and our products and brands. And for these reasons, again, these often create new challenges. So I'm excited for the practice and those who are interested in IP, because I believe that in my lifetime, it's just continued to grow and grow and grow exponentially. And I think someday there won't just be IP experts or patent experts, but they'll be even further divided among,
Yes,
if you will.
definitely.
And I think that's headed in that direction. Everybody
Yeah.
says, oh, do you do transactional litigation? And then it becomes, if you will, almost literally that I do software litigation, or that I do domain litigation. So,
Yes, yes.
so yeah. Also, last comment, the technology is changing the distribution of legal services. I mean, AI can answer our questions faster than ever before. I can type in a Boolean search and ask it a question and get, law spit out that when I got out of law school, you had to go read in a book and make copies and retype, and now you can cut and paste in moments. So again, we have outsourcing of these services over national lines and to companies. So as AI increases to improve the predictability and how do you say, the importance of statutory law and stare decisis, other cases in our jurisdiction that govern the decision, I think the role for lawyers is actually going to decrease in terms of how briefs and law is presented. And for those reasons, again, I think we need to stay creative on the arguments, and because we are not robots, we need to be,
Yes.
beyond that, above that.
Definitely. We are not robots. We are beyond that. And as you said, creativity is something that we need to use more and more. Stephen, it was wonderful speaking with you. I got to learn so much, and I'm sure that this session is super valuable to all our listeners. Thank you so much for your time and your willingness to share.
Well, thank you. I'll see you again soon.
Hey there, thank you for attending today's session. If you enjoyed today's session, do follow our channel and consider sharing it with a friend. My name is Priggya Arora, daughter of inspiring parents, alumna of IIT Kharagpur, engineer turned lawyer and entrepreneur, and now founder of PL Legal, where we help creators and innovators protect their intellectual property. Thank you.